Donald Trump made a "my lips are sealed" gesture outside his civil fraud trial today, but he was anything but tight-lipped on the stand.
Extraordinary tension inside that courtroom, with Donald Trump really pushing and pushing and pushing the judge.
Trump sure looked ready for a fight as he glared at the camera. He clashed with Judge Arthur Engoron from the moment he took the stand, giving long speeches instead of yes and no answers. This is a very, very unfair trial. Very, Trump complained. Control your client, the judge told Trump's attorneys. If you can't, I will. He even snapped at lawyer Alina Habba, telling her to sit down when she insisted maybe he should listen to Trump's long-winded rants. She hit back outside the courthouse.
I was told to sit down today. I was yelled at, and I've had a judge who is unhinged slamming a table. Let me be very clear. I don't tolerate that in my life. I'm not going to tolerate it here.
A sitting federal judge locked eyes with Donald Trump and told him directly, explicitly on the record, to stop talking. And the instant Trump opened his mouth inside that courtroom, the entire structure he had spent 5 decades constructing began to fracture. Not because the judge came in hostile, not because the proceeding was designed against him, but because Donald Trump, a man who has sold the illusion of invincibility for half a century, had finally walked into the one room in America where performance carries zero legal weight and confidence is not a substitute for evidence.
Things got so heated that less than an hour in, the judge called for a 15-minute recess in an attempt to cool things down. But when Trump came back, his attitude was unchanged. He called the attorney general a fraud and the entire trial a political witch hunt.
Because it's a scam.
When he was done testifying, he declared the day a win for him.
You saw what I had to say today, and it was very conclusive. Everything we did was absolutely right.
He may feel emboldened by bombshell new polls that show him beating President Biden in 2024.
What detonated inside Judge Engoron's courtroom that day is among the most psychologically exposing things any defendant has ever done to his own case in a public legal proceeding. And here's the part the coverage almost universally failed to capture, the part that, once you understand it, rewires how you interpret every single moment of what you watched. This case was never fundamentally about manipulated balance sheets or bank fraud allegations. Those were the legal surface. What lived beneath the surface was something far more raw, one man's lifelong total dependence on his own constructed mythology, and the collision that happens when a legal institution refuses for the first time to absorb it.
Trump and his children have denied any wrongdoing. And while Trump just took the stand about an hour ago, the judge has already accused the former president of treating this appearance like a political rally. The judge has urged Trump's lawyers a number of times to control their client. Let's go right to NBC's Vaughn Hilliard outside the courthouse. Vaughn.
Courtroom for a morning break after a contentious first 90 minutes of Donald Trump on the stand and under oath, facing questions from the New York Attorney General's prosecution. But for Donald Trump, much of this was included interjections from the judge, Judge Engoron, who already has fined him twice for violating a gag order for attacking a member of his staff. But for this instance of Donald Trump on the stand, it was condemnation for the judge for giving, in his words, a political rally and speeches and not answering the actual questions from the New York Attorney General's prosecutor. At one point, the judge ordered Donald Trump's own attorney, Chris Kise, and Alina Habba to sit down after both were making the case that Donald Trump is free to answer the questions as he sees fit, that this is, in their words, an unusual circumstance to have the former president of the United States and, in the words of Chris Kise, the future president of the United States on the stand answering questions under oath, and that he should be able to build the narrative that he sees fit. Donald Trump on the stand called this an unfair trial and suggested that he was being politically targeted, which again was met with condemnation by the judge, who at multiple times had suggested that Chris Kise, his attorney, should pull his client aside and talk with him because he needed to answer the questions put forward by the New York Attorney General's office.
The spectacle that every outlet covered wall to wall, the confrontations, the grandstanding, the moment he refused to yield the floor, the walkout, none of it was a breakdown. None of it was Trump losing his grip. Every calculated second of it was the strategy executing exactly as designed. And I am going to show you with precision what that strategy is going to cost him.
The defense team's own witness, a former Trump Organization executive named Jeffrey McConey, who is a co-defendant in the case, may have provided a direct link between the ex-president and the alleged exaggerations of the value of his properties. According to Business Insider, quote, McConey had been called to the witness stand by the defense, but on cross-examination by lawyers for the state attorney general's office Tuesday, he linked Trump firmly to the conspiracy and fraud counts that have yet to be decided in the non-jury trial. McConey was handed People's Exhibit 3054, a draft of Trump's net worth statement for 2014. He was asked to look at a note scribbled in thin blue ink on the draft's first page, DJT, to get final review, which he said he had written. The AG has alleged the net worth statement that McConey was handed the draft for from 2014 contained $3.5 billion in exaggerations. McConey also broke down in tears on the witness stand, saying that the mounting legal investigations led him to retire from the job after 35 years. Joining our conversation, New York Times investigative reporter Suzanne Craig is back, and with me at the table, MSNBC legal analyst Lisa Rubin and New York Times editorial board member Mara Gay. Susan, how did Jeffrey McConey's testimony read to you?
I mean, it wasn't great. I think in a trial of not a lot of great days for Donald Trump and the Trump Organization. You know, there's a document that's out there. It's as you mentioned, the 2014 statements of financial condition, and right on the top of it, it says DJT to get final review, and it really does tie Trump to the document. We don't know if he got final review, but it shows there was some sort of acknowledgement in the organization that Donald Trump would sign off on these documents. And you know, Donald Trump has really tried to distance himself from this. He has said that he has an army of accountants and lawyers who look at these things. And I always think it's interesting with the Trump Organization, you hear on the one hand, they're a mom and pop organization, very tightly run, you know, from the top down to the point where Donald Trump, up until the time he went to the White House, was signing every check that went out the door. But then you have, when it suits them, they're a large organization and they really don't get into the minutia of things like statements of financial conditions and audits. They rely on others. And the testimony from, I think, Jeff McConey yesterday really did tie the president, at least in some way, the former president in some way, to the financial statements. And that, you know, is significant.
Well, I want to ask you, Lisa, about that. According to Business Insider, the spreadsheet czar had testified on direct examination Monday that he would review each year's draft net worth statement with former Trump Organization CFO Alan Weisselberg, who would then give the approved draft to the outside accounting firm Mazars USA, which would print the final statement. Quote, I believe there was a step in between that involved Donald Trump prior to 2017, state lawyer Andrew said to McConey, who appeared uncomfortable on the stand as he said Trump indeed did the ultimate signing off. McConey's many handwritten notes indicate it was Trump and his top executives who made the last edits and then signed off on these net worth statements. As such, the notes do serious damage to the primary Trump defense. Blame Mazars, blame the accountants. Is this a direct link?
I think it is a direct link, but you don't even need this document, McConey's testimony, to get the direct link, because Donald Trump himself gave it to us on November 6th. He was on the stand with Andrew Raymer, who also did the examination yesterday, and he said, is it correct that you had reviewed the statements of financial condition in each of the years from 2011 to 2017 before it became final? And Donald Trump's answer, and I'm reading to you from the transcript, Alicia, is, yeah, I would look at them. So you had it from the horse's mouth. You didn't need Jeff McConey and his handwriting and the attorney general confronting him with things that put sort of a wrench in the narrative about blame it on Mazars. Donald Trump was willing to admit it himself when he took the stand.
And yet, when we talk about Trump's legal team and the choices that they make, it is noteworthy that they chose, this was their witness. Right. This was their witness who then added, perhaps they did not need it, but added more data points to suggest that Donald Trump indeed knew what he was doing.
Well, one of the other interesting things about the Trump Organization, and this was true in the White House as well, is that we know that Donald Trump chose people around him who were sometimes competent but always loyal. And so, you know, what we're seeing here is that even with a bevy of lawyers whose sole purpose was to protect Donald Trump, whether or not something illegal was going on, there were mistakes made. And in a way, the more cooks you have in a shop, the more complicated that becomes. So the very people who he hired thinking they're going to protect me, they're going to prevent me from putting my own name at risk, actually now may have kind of sealed his fate. And so I do think it makes a difference, at least to the public, to see, Donald Trump to get final approval on this. I mean, it's true. We've heard it out of his mouth. We've seen it. There's a trail there. But there's something that feels different about putting it in writing, because Donald Trump is known for never putting anything in writing. And here it is, plain as day at the top of the document.
Sometimes competent, always loyal definitely belongs on a mug or on a t-shirt. Susan, I want to read this to you too from Business Insider. Quote, in one key cautionary note from the 2015 draft, McConey made a notation in ink that this computation also includes forecasted deals that have not signed yet.
Now let's cut through everything and get to the structural reality of what actually occurred, because the footage makes this case far more effectively than any headline writer managed to. Listen with precision to how the judge delivered his warning, because he was not expressing frustration with the difficult defendant. He was constructing a legal instrument for the penalty phase. The judge issued an explicit on-the-record warning to Trump's legal team. If Trump continued refusing to give direct answers, if the speeches continued in place of yes or no responses, negative inferences would be drawn when calculating the magnitude of the financial penalty. That is not a judicial scolding. That is a loaded mechanism pointed directly at Trump's assets. The judge was communicating to every person in that room with total clarity. The way this defendant is conducting himself on that stand is going to increase the dollar amount he owes, not his reputation, not his public image, his actual money, actual numbers, actual asset seizures. And Trump's own lawyers were powerless to halt it. When the court directly asked whether Trump's legal team could guarantee their client would comply with the most fundamental rules of sworn testimony, rules any first-year law student could recite, they could not provide that guarantee. They stood before a federal judge in a civil proceeding and confessed openly that their own client was ungovernable on the stand. That confession is the signal that cuts through everything else. That is the moment that tells you exactly what you are dealing with. But here is the critical context that almost no coverage delivered with the clarity it demanded. The context that transforms the meaning of every single thing you watched unfold in that courtroom. Trump was not present that day to contest his innocence. The judge had already resolved the question of guilt in a formal written pretrial ruling issued months before this hearing existed. That ruling documented in precise legal language that Trump had systematically and substantially inflated the value of his properties and assets when presenting them to banks and insurers, not by marginal appraisal differences, not by figures within any reasonable range of dispute, but by billions of dollars. That ruling was challenged on appeal and survived. It was not voided on procedural grounds. It entered the legal record as established, documented, adjudicated fact, because that is precisely what it was. The proceedings everyone watched, the confrontations, the speeches, the judge cutting the microphone, none of that was a guilt determination. Every moment of it was a penalty hearing. The singular remaining question in that room was one number. What is this going to cost him? And Trump spent every minute of his time in that courtroom driving that number upward. Understand concretely what that means. Imagine representing to a bank that your property is valued at $2 million. Every independent assessor who examines it places the value at $400,000. The bank extends credit based on your figure. A court subsequently examines the transaction. The proceeding you now sit in is not convened to determine whether you misrepresented the value. That determination already exists in writing. This proceeding exists solely to calculate what you owe for having done it. That was the legal environment Trump occupied when he launched into his extended grievance monologue. He characterized the proceedings as politically motivated inside the same courtroom where the judge had already documented in writing that the fraud occurred. He presented himself as an innocent man in a forum that had already resolved the innocence question against him. He invested his time in a penalty hearing doing everything within his power to maximize the penalty being calculated against him. The negative inferences warning the judge delivered was not rhetorical. It is a defined and operable legal mechanism. When a witness under oath declines to answer a direct yes or no question with a direct yes or no answer, the court is legally entitled to interpret that refusal as an acknowledgement that the truthful answer would damage the witness's position. The judge can incorporate that inference directly into the penalty figure. The legal designation is consciousness of guilt. Trump was generating documented evidence of it with every deflection, every extended monologue, every forced judicial intervention. His own attorneys, standing in open court, incapable of assuring the judge their client would observe the most elementary obligations of sworn testimony, had delivered a statement of enormous legal significance. This defendant operates under the conviction that these rules were written for other people. Now here is where this ascends from legal analysis into something genuinely revealing about the architecture of this man's psychology. Trump arrived at that courthouse having choreographed what appeared to be the dominant visual of the day, the sealed lips gesture for the cameras waiting outside, a performance of iron self-discipline captured and distributed to supporters who prize visible composure. Then 30 minutes later delivered the courtroom speech that prompted the judge to cut him off entirely. Those two moments are not contradictions. They are consecutive scenes in a single production aimed at two separate audiences with total deliberateness. The sealed lips for the supporters who needed to see a man in command of himself. The defiant courtroom speech for the supporters who needed to see righteous fury aimed at a system trying to destroy him. Both images captured. Both circulated. Both functioning precisely as engineered. This is not the story of a man whose composure shattered under pressure. This is the story of a man who has spent 50 years inhabiting rooms where his spoken word was the governing authority, where he held the deed to the building and therefore his valuation of it was the valuation that stood, where he signed the paychecks and therefore his assessment of performance was the assessment that counted, where he controlled the production and delivered the verdict on camera himself. Every room Donald Trump occupied for 5 decades was a room where the narrative bent toward him because he controlled who stayed and who was removed. A federal courtroom is the single space in American civic life where that dynamic is architecturally, structurally, and irreversibly inverted. You do not control the exits. The judge does. You do not author the narrative. The evidentiary record does. You do not hold the floor indefinitely. You answer the specific question directed at you. And when you refuse, the penalty grows. What Trump anticipated when he entered that hearing was the outcome that had materialized in every other room across 5 decades of his life. That through volume, through repetition, through the relentless projection of absolute certainty, the room would eventually accommodate him. The judge instructing his attorneys to control their client was not merely a procedural intervention. For Trump, it represented something genuinely foreign. A room that processed his performance without yielding to it. And then there is the detail that deserved to anchor the entire day's coverage and was instead buried beneath personality clash framing. All of this, every word of it, unfolded on the same morning that law enforcement responded to a bomb threat at Judge Engoron's private home. Not an ambiguous security concern. Not an unsigned letter. A bomb threat at the residence where a federal judge lives. Arthur Engoron received that information. He got into his vehicle. He drove to the courthouse. He took his position on the bench. He ran the session with complete composure. He issued the warnings. He enforced the protocols of his own courtroom on the same morning that someone had threatened to kill him for doing exactly that. And the narrative the country consumed by the end of that day was framed around a personality conflict between a famous defendant and a judge, not around what it actually requires and what it actually costs to keep that courtroom standing and functional. Hit the like button, subscribe, and activate notifications because Trump Mana Empire is tracking every development in this case as it moves forward. We will be here for every ruling, every revelation, every moment the system holds or fractures. See you in the next one. Stay sharp.